Cat Matlala has struck again, and this time, he is making sure he doesn't go down alone. Everyone who dined with him is now desperately scrambling to cover their tracks. Panic has officially set in. Yesterday in court, Cat Matlala pleaded guilty to charges of corruption, money laundering, and a long list of other crimes. He admitted to the judge that out of the 228 million rands awarded for the Medicare24 contract, he used a significant portion to bribe high-ranking police officers, pocketing a staggering 50 million rands for himself. He proposed a plea deal to the judge, a 15-year sentence structured so that he serves 8 years behind bars, with the remaining 7 years suspended. In exchange, he has promised to expose every single police officer who took a bribe from that 228 million rands contract. Now all the officers who benefited from this money are panicking. They are rushing to court in a desperate bid to block Matlala's plea deal. But all we can say is, sorry, your time is up. It is time to reap the spoiled fruits of your dirty labor. The first top cop to react to this bombshell is suspended police chief Fannie Masemola. He immediately ran to his lawyers, and today in court, his lawyers filed a petition demanding full access to the contents of Matlala's plea deal. Masemola is clearly in a rush to clear his name. He's so scared now. You need to see how he was sweating in court and begging as if his life depended on it. My brothers and sisters, this is just the beginning. Many officers are going to start running to court now, because the list is full, and they're all going down. If you want to see these corrupt officers exposed and brought to justice, hit that like button right now. Share this video with everyone you know. Subscribe to the channel, and turn on the notification bell, so you never miss an update. Type jail them now in the comments section below. Let's stand together and demand that these corrupt officials are held accountable. Now let's take a look at the footage of Fannie Masemola and his lawyers in court, fighting to get their hands on Cat Matlala's plea deal. Jabulani, roll the clip.
Particular stage. And that will also involve further disclosure, Your Worship, which the state will happily make such disclosure at the appropriate time. As it stands now, the state is prepared to make disclosure in terms of the evidence in respect of all of the accused before court, and we stand by our arrangements.
Good. Thank you. So, in other words, the plea and sentence agreement, if it is approved, will be made available as part of the disclosure. Is that correct?
At the appropriate time, Your Worship. I add in that because there might be additional accused charge, so we'll have to just hold on to it until we finalize what we need to finalize in respect of additional accused, etc.
Thank you very much. After the proceedings on Wednesday, I think it was Wednesday. Was it Wednesday?
The 24th.
Where accused number 1 appeared.
24th, yes,
Yeah.
Worship.
I think I omitted to indicate on the front page of the J15 the separation, so I'm just going to do it now.
As the court pleases, Your Worship.
Good. In respect of the accused present before court, I believe that you've all heard what was said here, and it's not necessary for me to repeat everything. The matter postponed until the 28th of August this year in Court 16, and I've written on the record that it is for the finalization of the disclosure. The accused 2 to 7, 10 to 16, they are on bail, which is extended on the same conditions and warned for 8:30 in the morning. And accused number 17 is released on warning for 8:30 in the morning. 28 August this year in Court 16. Do you all understand? Good, thank you.
Court, please.
Thank you. Court adjourns.
Under Sekakani SC. I would also like to tender his apology for today. He had other pressing matters, as it pleases the court.
Good. According to the charge sheet, the matter was previously postponed until today for further investigation and for the disclosure. What is the position?
Your Worship, before we get into the issue of disclosure, we also postponed the matter for the charge sheet to be amended to incorporate accused number 17 in the preamble. However, that has not been concluded as of date hereof, due to the following reasons. Your Worship, accused number 1, 8, and 9 have been withdrawn from this charge sheet. Those accused are appearing in the Specialized Commercial Crime Court, Your Worship, in terms of a Section 105 plea agreement. The plea agreement was tendered in the SECU. Judgment will be delivered on the 1st of July, 2026. Your Worship, if the outcome of the plea agreement is positive, there will be further changes, possible changes to the charge sheet, which could include additional charges against some of the accused that are before court. It could also include the possibility of additional accused being added to this particular matter. That will obviously result in the charge sheet changing again, Your Worship, and hence we have not finalized the charge sheet at this stage. Your Worship, in terms of the matter of disclosure, on the last occasion, the 13th of May, the state requested that each of the legal representatives provide the state with a 120 gigabyte USB so that the state could copy the contents of the docket for them. Your Worship, this morning, most of the legal representatives did provide the 128 gigabyte USB. I just wish to confirm which of the accused provided such devices to the state. Accused number 3, legal representative. Accused number 4, 5, 6, 7, 10, 11, 12, 13, 14, 15, 16, and 17. The two outstanding USBs, Your Worship, is in respect of accused number 2 and accused number 7.
Yes, you already see. You mentioned 7 as one that provided.
I beg your pardon, Your Worship. They didn't.
They didn't.
Yes. Your Worship, the process that will unfold henceforth is that the state has canvassed this with my learned friends. The state has indicated to them that the state would require approximately 2 weeks to copy all of this information onto the memory sticks. That would take us to mid-July, which is about the 15th of July, 2026. The state then requested for them during the latter part of July, the last 2 weeks of July, that they come to the offices of the state at the CSR building. We will provide them with the copied USBs, but they need to come with their laptops so that we could connect up the USBs to their laptops, open it, and so that they can also satisfy themselves that what we have is what they have. And the issues of opening documents, etc., must be resolved in that period. Your Worship, the legal representatives have indicated the dates that they will be attending at our offices. We have a record of those dates. I do not think it's necessary for me to place that on record.
I don't think so. If you're all in agreement with the dates and appointments, then it's fine.
As the court pleases, Your Worship. Your Worship, what the date we then proposed is that if the disclosure process is concluded by the 31st of July, we have agreed on a date. My colleague just informed me now that the date that we agreed on, the state has another matter in court, and so that date does not become viable. However, we've suggested 2 dates to them, one being the 21st of August and the second being the 28th of August. And it would not be my request then, Your Worship, that the matter be postponed to the 28th of August, where all of these processes will be concluded. As it please.
Is there a plan of action? Advocate Moyawa?
May it please the court, Your Worship, I do confirm the arrangements as far as meeting with the state officials, further with the issue of the next date, the 28th of August. May I just address the court on a few aspects, Your Worship. On the last occasion, it was placed on record that for accused number 17, they were meeting with the prosecution team and there were investigations that were being conducted from that particular meeting. It was never disclosed what those investigations are, so I just wish for it to be placed on record whether the state is at liberty to disclose what those investigations are, number one, and number two, will they be making that information available to the defense? Further, Your Worship, I suppose my learned friends have addressed the issue of the amended charge sheet that will be provided. However, with the issues or the proceedings that took place yesterday in the Specialized Commercial Crimes Court, once those particular proceedings are concluded, will we also have the Section 105 capital A agreement and whatever evidence that might emanate from there. I just wish to place that on record that we will be requesting that as well. But otherwise, we confirm the 28th.
Thank you, Mr. Mnyawa. Mr. Matikimela.
As it pleases the court, Your Worship, thank you so much. Your Worship, I confirm the arrangements that have been entered into with the state. But secondly, just to confirm the suitability of the 28th of August date. It's in order.
And also the appointment with the prosecution?
Correct.
Good. Thank you.
As it pleases the court, Your Worship.
Advocate Mataboge.
God pleases your worship, I confirm the arrangement as far as the appointment with the state. Secondly, I confirm the date of 28 August as being suitable. And the point that was raised by my learned colleague regarding further discovery was discussed with the state, and I think it will be sorted. Thank you, Your Worship.
Thank you. Mr. Fulbright?
Bishop, as the court pleases, Bishop, confirm what the state has placed on record. I also confirm, Bishop, that I've got an arrangement that we will, this afternoon at 12 o'clock, attend to the offices of IDAC to furnish them with the either USB and or a hard drive in respect of accused number 7. I've got previous appointments with other individuals attached to the IDAC, so it coincides with that, Bishop, so that there is suitable arrangements from our side that's acceptable, I assume, to the state. And I also confirm, Your Worship, that once we've received the disclosure or discovery, we will engage the state in terms of comparing what they have vis-a-vis what we have. We've gone through this exercise many times with the state, so I'm aware of the processes. Also, from accused number 7 side, we will impose on the state to furnish us the details within the 2-week period in order for accused number 7 to make written representations to the state in terms of this matter against him as a court pleases.
You confirm the date as well?
Confirm the date.
Mr. Loeffler, you already addressed me. Then we move to Advocate Bishop.
Sorry, Your Worship. I confirm the arrangement and the date.
Mr. Mashishi?
As the court pleases, Your Worship, I also confirm the arrangement made with the state in relation to the viewing of the contents of the dockets, and as well as the availability on the date of the 28th, Your Worship, is suitable with the defense. Safe not to repeat, Your Worship, will also request any other information that has been requested by my learned colleagues as well in relation to the plea. Thank you, Your Worship.
Thank you. Mr. Seleka?
As it pleases the court, Your Worship, we confirm the arrangement made with the state and also the suitability of the 28th. All is in order, Your Worship.
Thank you.
As it pleases the court.
Advocate Lepondo?
As it pleases the court, Your Worship, the date of the 28th suits both myself and the client and the instructing attorney. I have an arrangement with the state that I'll collect the memory stick on the 21st of July at 8 o'clock in their offices. We also request that we be furnished with the plea and sentence, copies of the plea and sentence agreement in respect of accused 1 and his companies, as it pleases the court.
Thank you. Ms. Whittle?
Pleases Your Worship, I confirm the arrangement with the state as well as the further discovery that will be requested, and I also confirm that the date is in order.
Thank you. Ms. Kubeka?
May it please the court, Your Worship. Your Worship, I confirm the arrangement that has been made, and I further confirm that we will be attending on the 28th of August, Your Worship.
Thank you. And Advocate Munyapao?
May it please the court, Your Worship. Your Worship, I do confirm the arrangements and further note the prospects of potential changes in the charge sheets in respect of accused number 17, pending the appearance on the 1st of July. But the arrangements of the 28th is in order, Your Worship.
Thank you.
As it pleases the court.
Thank you very much. Advocate Manelal, do you want to address on the concerns or issues raised by some of the legal representatives?
Yes, certainly, Your Worship. Firstly, Your Worship, I just wish to confirm that counsel for accused number 2 has provided us now with the 128 gigabyte memory stick.
Good.
Your Worship, regarding the submissions made by Counsel for Accused Number 4, just to address the issue of what was the investigations that was outstanding. Your Worship, in essence, on the last occasion, the 13th of May, I did indicate that some of the aspects of the investigations had not been finalized, and that related more especially to the financial investigations, Your Worship. That required for bank statements to be obtained, for cash flow analysis to be conducted, etc. In essence, Your Worship, that aspect has been concluded, and therefore the state is in a position to make disclosure. The state has offered to make such disclosure based on the fact that most of the investigations have been finalized. However, Your Worship, in respect of the 105 plea agreement before the SCCU, that has not been concluded yet, and if it is confirmed in the positive, Your Worship, the dynamics will change in respect of the state possibly adding further accused. However, notwithstanding that, the state will make disclosure in terms of the accused before court, as indicated now. If there are further accused added, etc., that we will deal with when we get to that.
Did you see that? The panic in that room is absolutely palpable. This is just the beginning, and every single one of them is eventually going to have to dance to the tune of their own music. We are not backing down, we are going to expose them all. Now let's watch the explosive moment in court when Cat Matlala completely nailed everyone involved. Jabalani, roll the clip.
It's from Mr. Matlala in respect of his children. Mr. Makubela is best placed to address the court in respect thereof. So with your leave, I'll allow him to address you on those.
Thank you. Yes.
Maluleke, Your Worship, I see my colleague has made a mistake. I just want to correct the record. Indeed, we have consulted with the accused with regard to the situation concerning his children. We've also gone as far as trying to reach out to his wife, who is present before court. And the position is that he has he's a primary caregiver out of 6 of his minor children. That being Kwetsi, Leranzo, and Lulu, aged 12, 10, and 11, as well as Ntokozo, Subusiso, and Malaika. Although Ntokozo is 21 years old, Subusiso is 20 years, Malaika is 16 years old. The position is that, in fact, apologies, Your Worship, I misread it. The other 3 minor children is Vusi Jr., is Shoki, Ganyezi, and Subusiso. They all reside in his house in Mistri. He is 100% responsible for all their living expenses, their support. That will include also the issues of school fees and all medical related issues to do with these minor children.
If you look at the definition of what is a primary caregiver, it excludes if it's a mere breadwinner or person responsible for the finances or looking after the children financially. It is more focused on whether this person is the one that takes care daily of the children's emotional needs, feed them, get them ready for school, ensure that they attend school, etc. That is a primary caregiver. Does your client fall under such?
Ever since he's been incarcerated, it no longer falls under that, but prior to his arrest, that was his responsibility.
Those aspects I've mentioned now.
Yes.
Are there then people that are now taking care of the children?
Your Worship, may I approach my colleagues? Seems like they are trying to get my attention. Thank you for the indulgence, Your Worship. Your Worship, that is the role that he was playing prior to his incarceration. I must just add that of the 6, 3 are based in a different house, wherein his current wife resides. And she currently is the one who's fulfilling that position in the interim. Let's go, please.
Yes, sir. How does this change everything?
Worship,
There's a clear duty on this court, in line with constitutional decisions, that I have a duty to ensure that the children are looked after, best interests are looked after. And now it comes to light that the accused is a primary caregiver, and it is still unclear as to who is taking over that role, whether it still be looked after. How does that impact on your plea and sentence agreement? Because at the end of the day, I must still evaluate all the evidence prior to me establishing whether this is a just sentence. Advocate, are you able to confirm then that the prosecutor who then entered into the plea and sentence agreement with the accused persons consulted with the person charged with the investigation of the case and had due regard to the nature and circumstances relating to the offence, the personal circumstances of the accused persons, previous convictions of the accused, if any, and the interests of the community, this in compliance with section 105 capital A subsection 1B Roman 1 and 2.
Your Worship, I do confirm that we have in our possession an affidavit by Senior Criminal Investigator in the Investigating Directorate Against Corruption, Mr. Sunil Belochan. Your Worship, he has deposed to an affidavit. May I have leave to hand it in?
You may read it into record.
As the court pleases. Your Worship, my learned friends have been provided with a copy of this document as well. I, Sunil Belochan, do hereby make oath and state the following. 1. I am employed by the National Prosecuting Authority of South Africa as a senior criminal investigator in the Investigating Directorate Against Corruption. I am the lead investigating officer in Silverton CAS 285/03/2026. 2. The facts deposed to herein are derived both from the affidavits obtained, documentation at my disposal, and from my personal knowledge, both true and correct. 3. The investigating director, as head of IDEC, authorized an investigation into this matter. 4. The accused in this matter are 4.1 Vusimuzi Matlala, accused number 2. 4.2 Medicare24 Tshwane District Pty Ltd, accused number 2, represented by accused number 1. And 4.3 Luxo Africa Brand Investments Pty Ltd, accused number 3, represented by accused number 1. 5. Accused number 1 appeared in the Pretoria Magistrates Court on the 26th of March 2026. 6. Accused number 1 was requisitioned from custody as he was in the custody in an unrelated matter. 7. Accused number 1 did not apply for bail in this matter. 8. Accused number 1 was thereafter served to appear on behalf of accused number 2 and accused 3 in terms of section 332 of the Criminal Procedure Act. 9. During the first appearance of accused number 1, the accused indicated that he would like to enter a plea and sentence discussions with the state. 10. The authorized prosecutors, Deputy Director Advocate S. Manilal, Senior State Advocate R. Creel, had discussed the plea and sentence agreement with me on the 22nd of June 2026. 11. I understand that the accused will plead guilty as set out below. The charges, count 1, fraud. The charges are reflected in Annexure D, were perused by me wherein the SAPS awarded the accused number 1 and 2, a tender in the amount of 228 million 12.2, the SAPS paid Medicaid Swane District, accused number 2, the amount of 50,310,590 rands per 68 cents in 199 payments to the actual prejudice of SAPS. 12.3, the contract was obtained by way of fraudulent misrepresentations. 12.4, the accused therefore plead guilty to count 1 as contained in the charge sheet and admit that they have no valid defense to same. 12.5, counts 2 to 4, the corruption charges. 12.6, after SAPS paid Medicaid 24 Tshwane District, accused 2, the amount of 50,310,590.68 in 199 payments, accused number 1 as the sole director and owner of Medicaid 24 Tshwane District, accused 2, and director and majority shareholder of Luxo Brand, Africa Brand Investments, accused 3, paid multiple SAPS members from the proceeds of the fraudulent tender award. 12.7. These payments to public officers being SAPS members were unlawful and intentional and constituted gratifications for their facilitation. 12.8. The accused paid 1 Rachel Macheng, a member of the SAPS, who was stationed in the division, Forensic Science Services. Macheng was one of the end users of the services that were rendered by accused number 1 and 2 in terms of the contract awarded to accused 1 and 2. 12.9, Macheng's role and responsibilities within SAPS was abused in that she referred multiple members from SAPS for medical screening to accused 2 that resulted in purchase orders being issued in relation to the services that accused 2 was contracted to provide and thereby enabled accused 2 to invoice the SAPS whilst receiving undue gratifications from accused 1. 12.10, the funds were made to Macheng in a clandestine manner in order to prevent detection of the said payments as follows. 12.11, electronic funds transfers were made from the First National Bank account number 6282441161 of accused 2 to the First National Bank account number 630209562223 of Luxo Africa Brand Investments, accused 3, of which accused number 1 held directorships in both accused 2 and 3. 12.2. From the First National Bank account of accused 3, account number 6247888190, funds were transferred to an account held by Ozweni Meat Hyper Pty Ltd, which was nominated by Rachel Macheng. 12.13. The funds were thereafter transferred from the First National Bank account of Ozweni Meat Hyper to the personal account of Modigi Christina Kekana. 12.14. Subsequently, the funds were in the personal account of Christina Kekana, account number 93655066146, was withdrawn and made available to Macheng. 12.15. A total amount of 300,000 was paid in tranches in amounts of 100,000 in 3 equal payments to Macheng. These payments were made in or about 13 January 2025, 4 February 2025, and 17 March 2025. Counts 12.16, counts 5 to 7, and the money laundering charges. The accused, being accused number 1, 2, and 3, contravened Section 4 of POCA, 12.18, in that the movement of funds emanating from the contract induced by fraud, as set out above, through various accounts as set out in paragraph 48 above, resulted in the disguise or concealment of the nature, source, origin, movement, location, or disposition of the said funds. 12.19. The funds amounting to 50,310,590.68 received by accused 2 from the SAPS as payments pursuant to the unlawfully awarded contract constitute proceeds of unlawful activities. 13. I understand that the accused will plead guilty to all counts as attached to the agreement. 14. I confirm that I have been consulted with due regard to, amongst others, the AA, nature of the circumstances relating to the offence, B, personal circumstances of the accused, C, previous convictions of the accused, if any, and D, interests of the community. And 15. I understand that the accused will be sentenced as stipulated in paragraph 84 to 91 of the plea and sentence agreement. 16. I confirm that I have had insight into the proposed plea and sentence agreement, and after consideration of all factors mentioned therein, I am in agreement with the proposal. Consultation with the complainant. 17. Major General Charity Matlala of the South African Police Services was also consulted to me prior to concluding this affidavit. She and I agreed with the terms and sentences